Good evening, everyone, and I'd like to welcome you to the April edition of the Town of Kent Zoning Board of Appeals. Before we begin, please rise and join me in pledging allegiance to the flag of our country. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Okay, first item up on the agenda is a holdover from last month in the matter of 887 Gulf Ridge Road. Greg Allman. Good evening.
Good evening. My name is William Schilling, and I represent Greg Allman and Todd Bania, both of whom are here this evening. Joel Greenberg, who is the project architect, licensed architect, who gave a report to you guys, is here as well if you have any questions of him. And Nicholas Sandersaul is also here. He's a disabled vet from the Vietnam War who has been in the premises well before my clients took title in 2012. The property is 287 Gulf Ridge Road. It consists of 6 acres. The main house is a 3-bedroom house. The cottage is matching, and it's a 1-bedroom cottage with a private septic and a shared well. We seek an interpretation simply that this is a pre-existing non-conforming use. And if you approve it, it will be able to go on forever or until it ends under the New York State Constitution, the United States Constitution, the town law, and your code. I'm not going to go over all the facts again. You've heard me. You've probably heard me ad nauseum. But I would like to talk to you about a couple of the questions that this board asked and wanted some answers to, and I'd like to address them if I could. From my recounting of the meeting, I think there were 2 questions, and they were this: were my clients acting in good faith and without knowledge of any problems when they purchased the property? And number 2, there are clear discrepancies between the evidence we forwarded and the cards, the assessment cards that were part of the record last month. We'd like to address those 2 issues tonight. And in keeping with that, we submitted another submission last week, and it purported to answer, hopefully, some of the questions you have. And on the issue of good faith and was it self-created hardship, if you will, I submitted to you a closing statement from 2012 where adjustments were made for rent and for security. There was no surreptitiousness, there was it was out there that there was a tenant and he was paying rent. We also submitted to you a predate letter from Julie Butler, who opined that the cottage did predate code at the time of the purchase. We didn't know that at the time. We discovered it when we did some more research on the issues you raised. We also submitted an affidavit from my client's attorney at the time saying this was all on the up and up. We believed this was a legal residence, a legal predated residence, and he even relied on the Town of Kent building inspector saying that it was legally predated. We showed you a copy of the contract that said there were no violations, that the seller was committed to remove any violations that might exist on the property. And then we also submitted a copy of the mortgage page which said this lien encumbers property that are improved by 1 or 2 residents or 2 families. So I hope that at the very least we've convinced this board that my clients acted with the highest integrity, with the highest standards, in believing that this was a legally predated cottage, bolstered by the predate letter from the Town of Kent building inspector. So I believe their beliefs were justified. I believe they were correct in assuming that it was legally predated. I think it's important to note, and this is just an aside, that Harry Ward also gave a legal predate letter on this property years before, and it was his opinion that the date, the dispositive date for predating was 1956. I listened to Bill, the building inspector. Our benchmark is 1938. But I think it's interesting that other towns in our area are 55 and 62, and Kent's 1938, which makes things very difficult. But that's what we've tried to show you today. Now, on the second issue, which was raised by the board, was that of the assessment cards versus what we showed you. And we will acknowledge that our burden is 1938. Before I get to that, there's two things that I just want to stress to you. Number one, that I told you that there's a prevailing law on this issue as it relates to the difficulty one has in trying to show a state of facts 60, 70, 80, or 90 years ago, which was our burden today. And the court has accordingly afforded a lesser burden to people like my clients who are forced or trying to show something that happened 90 or 80 years ago. So our burden is reduced by a court of appeals, many court of appeals case, and I think that's important as I move forward. An appellate division court judge called it an insurmountable burden because when I go back to the 1920s and 30s, finding people alive to give testimony are very difficult, if not impossible. So we think we'd like you to remember that our burden is not as great as if the code was 20 years ago or 30 years ago. It's 80 years ago, and the house was built almost 90 years ago. The second thing I want to remind you is that there's a maxim in the law. I know a lot of you have been on the board a long time, so you've heard it before, but I'm sure you've all heard of it. But whenever there's an ambiguity, it's got to be ruled in favor of the landowner because ordinances limit the use, what a property owner can do with his property. So there's a maximum, and it's Adams versus Adames, the threshold case that says if there's a contradiction, if there's an ambiguity, if there's a contrast, if there's a conflict, that has to be ruled in the favor of the landowner as a matter of law. And trust me when I tell you, I'm not making that up. That's when I go to the board a lot with. And I'm hoping that you understand that as we go through the assessment card issue, I mean, there's ambiguity all over the place. There's contrast all over the place. And this ambiguity should be ruled in favor of my clients. With regard to that, I'd like to start with the threshold, with the benchmark, with what is our strongest piece of evidence, and that is a newspaper article, which I have here, I know you've seen it before, that establishes that the house, not the cottage, was built in 1929. And it goes on to say that they were at the house, at their new house, enjoying the Christmas holidays in 1929. And I hope we start with that being somewhat irrefutable, that is something that it's strong, it's irrefutable, it's there, it's in print. Yet, it's important to note that despite that irrefutable conclusion that I hope the board raises, there were 3 assessment cards that I attached as part of the record that suggest that the house was built in 1938, in 1934, and in 1940. So one of them is 11 years off, the other one is 8 and 9 years off, and one of them is 5 years off. But if you start with the premise that the house was built in 29, you'll see these assessment cards are all wrong. And again, you have to believe, as I do, that the newspaper article is irrefutable evidence that the house was built in 1929. So again, that assessment card, one of the assessment cards is 11 years off, and the others are 9 and 5 years off. Now, let's talk about the garage or the cottage. Again, starting with the premise that the house was built in '29, we've provided expert testimony from a licensed architect that says that there's too much in common. There's too much in common with the building of the house compared to the building of the cottage that would make one believe they were built in separate times. Even the toilets had the same model number and same make number. And I think it's impossible, or at least improbable, to think that in 1929 that house was built, and then 11 or 12 years later, they went and got the same model toilet and make. And the same thing's true with the trim, the same thing's true with the flooring, the same thing's true with the roofing, the same thing's true with the stone. So Mr. Greenberg is here to answer questions if you like, but I think that starts us off with a pretty good indication it was built simultaneously or shortly thereafter the house was built. I also submitted to you an affidavit from a previous owner who said, based on his knowledge, he was there a long time, based on his knowledge, it was always his knowledge and his belief that they were built together. And then I submitted an affidavit from a lady who was there in the 1940s who remembers that people were renting the place in the early 40s or late 30s, she said. And so this is the proof we have for predate, these three things. The assessment card gives us 3 dates. Part of your record, part of my submission to you. 1940 and 2 in 1941. And so it's very close, but if you look at the first analysis with with the house, which were 11 and 6 years off, being 3 years off or 4 years off isn't bad, but it still strikes me that you can't rely on the assessment card having been so wrong with regard to the building of the house. Respectfully, I would suggest to you that the building of a house, irrefutable time, with the expert testimony that the cottage was built at the same time or shortly thereafter, with the owner, a former owner, saying he knew it was always built at the same time, it was always his understanding, with an older lady remembering tenants in there in the early 40s or late 30s. Our testimony, what we're giving you, is much stronger than 3 assessment cards that have been proven to be wrong and false and misleading in the case of the main house. Our testimony is much stronger. The assessment cards have been proven to be faulty. And so clearly, if nothing else, you have an ambiguity. You have the town records, and you have what we've provided as the insurmountable proof that this was built prior to 1938. And then finally, I'd like to speak to one other issue that I think one of the members raised, and I just want to talk to it. Someone said, well, it might have been built as a summer house and morphed or evolved into year-round. And I provided in my submission to you the fact that that does not, the development of a seasonal house to a year-round house, doesn't invalidate the pre-existing non-conforming use. It keeps it in place. Just because it was enlarged or the use was enlarged, and the case I provided you says, that does not invalidate or terminate the pre-existing non-conforming use. So I'm going to conclude by just saying that I hope we met what we found to be an insurmountable challenge. My clients did all kinds of legwork to find what they could. We did our share. And I think we did enough to meet our burden. I think we've met our burden. I believe that this cottage is a legal predated use by any standards this board may apply. Building inspectors, 2 of them before, have said this is a predated use. There's an ambiguity here. It's got to be construed in our favor. Thank you very much. I'll answer any questions, or Mr. Greenberg, do you want to speak?
Just briefly. I think a lot of what is shown here has already been discussed by Bill, but just again, give you a visual again.
I think we showed some of this at the last meeting, but the top two are the original large house, and the bottom one is the cottage. As you can see, the siding, which is a very unusual siding, is identical. The stonework is identical, which certainly leads me to believe that the cottage could not have been built 10, 12, 13 years ago, after the original house. So I think that burden of proof we've met that burden of proof, and that there's no question that the cottage was built certainly within the same couple of years as the original house. And if you have any questions, we'll try to answer them.
I have no questions. Anyone have any questions?
Thank you very much.
Thank you.
Are you leaving, Mr. Schilling?
I'm sorry, I thought you guys said that.
No, I was about to make a couple of comments. Well, listen, the board can definitely appreciate the time and effort that everyone here has put into this endeavor. I would agree that there is a certain amount of ambiguity when it comes to dates. But I will, Mr. Schilling, one of the things that we requested, a board member requested, I believe it was Mr. Hanson, was that we were requesting some sort of documentation that showed this was a multi-dwelling.
The documentation that I provided you in furtherance of that was when you go to a closing and there's a rental, another dwelling, if you will, adjustments are made for security deposits and for rent. And I submitted that closing statement to you. Also, the mortgage document itself says this is to be improved by a single or two-family only. And I think that's what Mr. Hanson was looking for, if I'm not mistaken. So we think that's question number one, and we think I hope we address that. If not, we'll try to endeavor to get you more information. But it was adjusted as a two-family. There were adjustments made as a two-family. The Kent building inspector said it was a legally predated use, and the mortgage schedule envisions a two-family encumbrance.
Well, let's get back to that. The letter that was issued by, I forget the date, by Julie Butler, also stated that the living space was for domestic help only. And she went on to emphasize that fact on the letter.
Well, initially she said it's legally pre-constructed. With regard to the issue that it was for caretaker purposes only, it has no history. Our work has been talking to every owner along the way. For example, Mr. Marcus used it as a guest cottage, but he also rented it out. My clients have rented to Mr. Sandoval as a rental since 2012, and he's there before that. So I don't see, I read that, and I don't even think caretaker cottage is defined anymore. So I think the important part I got out of that letter was that it was legal predated, and if there's a restriction that the town thinks should be imposed upon it, then that would be the case. But I would argue strenuously that that's not the history of this cottage. It was never used as caretaker. Even the people back then said they used it as a guest cottage back in the 20s and 30s, and I spoke to one of them who bought it in 35 or something. They used it for guests or for, but not for caretaker use.
Well, you know, the issue here, to me at least, is not, we know the area exists. We know there's a good chance that the living space did exist, okay, and has been there for many years. The issue for me is the rental. That you have not met, in my opinion, the burden
I didn't know that burden was upon us. My burden upon us is to show that it's a predated use.
Well, you
I
have to
didn't know.
remember that you got a code enforcement violation for that reason.
Well, it was also a violation premised on the belief that it was not predated, I
Okay,
believe.
Here's what I'm going to do, and I'll give any other board member an opportunity to comment. I would like to hold this over again, okay? Because there is still information to be developed, and there's still questions that need to be answered, at least in my mind. I'll open it up to any other board member for their comment. Okay,
Well, no, so, look, I think you've provided a lot of information, and I think you're right, there's a lot of ambiguity around this. You know, I know personally I don't want to reject this because I think that I think you've met a lot of the burdens here, and I think the board would like maybe a little more time just to discuss it further before rendering a decision. I know that's my opinion. I think I'd like more time before rendering a decision because I want to just have everybody go over this information a little deeper, because it's a very unique case. You know, we get a lot of requests, you know, for accessory apartments, and we reject them for various reasons. Either they don't meet certain criteria. In your case, it's very unique. It is very old. There is a lot of differences between the dates in the cards. The newspaper article clearly shows that the house was there in 1929. So I don't want us to make a rash judgment, and I'd like us to take a little more time.
This will be the third time. I'm
I
not sure
know.
how rash it is, but
I know.
I'll let the board finish, and then I'd like to ask the board a question.
Yes,
if I could.
yes. Go ahead, I'm done. Another member have anything to say?
If I could ask, the caretaker cottage thing came out of nowhere. I didn't know it when I appeared before you before. It was when you guys asked for more information that I got the title from 12 years ago and found this letter. I didn't think it was germane to my application that it's a legally predated use. What is it specifically that I can get for you, Mr. Chairman, that would make you decide one way or the other? What's lacking that you want to see? I mean, let me ask you this, excuse me for interrupting. Have we established that the use is predated in your minds, and that now it's a question of whether it's a guest cottage or caretaker or unrestricted? What is it that you want from us so that we could try to answer your questions?
I think it's been established that the living space has been there, okay? What has not been established, at least in my mind, is was it a rental property since then? Was it used as a rental property? The other question that I still have not clear in my mind is is this indeed listed as a multiple family dwelling? I see the paperwork you gave me relative to the security instrument, and I see that it covers to be improved by 1 or 2 family dwelling units, but this is just an agreement.
Well, to go to your assessment card, each and every assessment card right now says it's RMF.
Right.
I mean, is that something that I should bring up next time? That the town recognize it as a residential multifamily?
Again, I'm going to reiterate, it's the rental issue. Also, we need, it's multiple family and it's the rental.
You know what, let's take a vote now. Let's just, are you ready to vote on it?
No, I'm not ready to vote.
You're not? Okay, so then we'll vote.
Yep. So for that, we'll communicate to you what we're looking for,
All right.
okay? And listen, we've spent a lot of time on this application too. We've done our homework,
Right.
and we certainly, you know, it's always been this board's mission to work with residents, okay? But there's certain questions that need to be answered. So I'm going to hold it over until next month, and maybe third time will be a charm. I don't know.
And
And I will
The board will-
communicate to you what we're looking
What you're
for.
looking for. And one more question, if I could, is, do I have to stop talking about the date of creation and now just talk about the use that's been in existence? Do I have to continue to show you that it was built prior to 38, or is that
No.
settled with the
I'm
board?
satisfied that it was built before 1938.
All right,
Yeah.
all right. thank
And
you
that's
very
why I think we need to just discuss it a little bit.
much. Can I walk out now? Thank you.
Yes. Thank you very much.
Thank you.
Good night, guys.
Good night.
I know.
Okay. What did I do with my agenda? Here it is. Thank you. Got it. All right, next item up on the next application to be heard is that of Robert Schwartz, 152 Lakeshore Drive East.
Mr. Schilling walked away with the sign-in sheet.
Did he?
Yes. Yeah, it's these attorneys, you got to watch them all the time.
I'll tell you, are the police here?
I'm here for Robert Schwartz. My name is Robert Bradley. Thank you. Thank you very much. Thank you. Mr. Schwartz on his property has sheds that are pre-existing that he got no permit for and no CO for. On the cover sheet here, if we take the first one, it has three sheds and a carport. Also on the property is a garage, which does have a CO for it. It was only the 1, 2, 3, 4, the three sheds and the carport. Certainly the benefits to the owner can't be achieved any other way but the sheds, I mean, the storage sheds. It makes no undesirable change to the neighborhood because there's a large fence around it, and every house in Lake Carmel probably has a shed around it. The request isn't really substantial. These are small sheds. It's not like this is a large garage or a barn that he's put on his property. They're relatively small sheds. It creates no environmental hazards where they are. And is it self-created? Oh, yeah. I mean, he did put the sheds up. But I think it outweighs the fact of, at this point, Mr. Schwartz just wants to get the variances requested from the zoning board and then go get permits and COs from the building department so he can clear up everything on the house. We've submitted a survey that shows where everything is located, and I don't know if you want me to go through what's needed, or is it on the things there? Okay. The second one I find more interesting is there's a small pond in the front yard. It's a fish pond. He spoke to somebody at the building department quite a few years ago who said putting a fish pond in the front yard would not be such a big deal and would not need a permit. He noticed that the birds were using this as kind of a bird toilet, and he built a roof over it. And at that point, it certainly became a structure. It's in the front yard. It's been there for quite a while. The roof is only up there to protect the fish, which are in there still. And he would need a zero lot line from the board. He needs a zero lot line variance from the zoning board in order to continue with his cover for the birds. And that's basically what I'm here for.
Well, as you're aware, we had an opportunity to take a look at the area, and I don't have any issues. that come to my mind. I'll open it up to the board for commentary.
I have no issues.
You have anything to say?
No.
All right, that said, there's no comment. I'm going to ask for a motion to approve.
I'll make that motion.
Do I have a second?
I'll second.
All in favor?
Thank you, gentlemen.
All right, have a good night.
And I did sign in. Take care.
Next item up on the agenda is Brelio Aponte, 63 Kent View.
Good evening, everyone.
Good evening.
Today I'm here because we're requesting a 3 feet side yard variance for a deck approximately 20 by 20 that we're building and a above ground pool in the backyard of our house.
Okay.
So,
Okay, I'll open this up to the board for any commentary.
Yeah, I just want to note for the record that it's only 3 feet he needs because the stairs are there, otherwise the deck itself is far enough away. So I see no issues.
yeah.
Okay. You want me to put that on the app?
No. No issues. Anybody else?
Anyone else have any commentary?
No issues. Any issues? Do you have the green cards that you sent out to your neighbors?
no, we haven't done that yet. We're supposed to, before we start the project, we gotta, I believe we gotta send out, right?
Yeah.
Well, before the variance,
Before the variance can be approved, we need to be sure that you made an effort to contact your neighbors and explain to them, that you're before the zoning board.
It has to be through mail because the.
Has to be through mail, return receipt request, certified return receipt, and then you bring these with you. You bring the
Okay.
receipts with you. So since you haven't done that, I'm going to hold this over for another month,
Okay.
okay? I'll hold it over until next month.
we also have accepted signed letters from your neighbors.
Yeah, Mr. Hanson raised the fact that we also have accepted in the past signed letters from neighbors. So if you want to present that in lieu of the registered return receipt to save you some time, that'll be acceptable.
Okay, all right, sounds good. I'll start doing that.
All right?
All right, sounds good.
Thank you.
All right, have a good
Take
day.
it.
Next item up on the agenda is Lloyd Oliver, 44 Longfellow Drive. Good evening, Mr. Oliver.
Good evening. So I'm here in front of you to get a variance for an after-the-fact shed on the rear of my property of 17 feet 4 inches.
Do you have your green cards?
I do, yes. Is it in there? Okay, it's not the lottery tickets.
Bring them up, please. Thank you. Are these representative of everyone that you've contacted? Has everyone
Yes,
gotten back to
This is
you?
what I was provided.
Okay.
And those are the people that I contacted.
Okay, great. Good? Brett? Okay, I'll bring it up to the board for any comments. Open it up. All right, there being no comments, do I have a motion to approve this application?
I'll make the motion to approve.
Do I have a second?
I'll second that.
All in favor?
Aye.
Thank you, sir.
Thank you.
Next application is Patricia Arndt, 212 Towners Road.
Patricia Arndt, and I'm here to get a variance to do a front porch.
Can you just lower the mic down?
Or else I gotta get taller.
There you go.
Patricia Arndt for a variance for a front porch at 212 Towners Road.
Okay.
And this is my contractor.
Brian Finney, 85 Brothers.
And we have the copies of your
Yes.
certified return receipts. And is this representative of everyone you were requested to contact?
Yes, sir.
Okay. I'll open it up to any board member for any comments on this application. All right, there being no comment, do I have a motion to approve?
I'll make that motion.
Do I have a second?
Is there anybody in the audience that would like to speak?
Is there anyone in the audience that would like to speak on this application? Okay, I have a motion by Ron. Do I have a second?
I'll second.
All in favor?
Aye.
Thank you.
Thank you.
Get to work.
Next on the application, and next application up is Patrick Marinan. I hope I didn't hurt your name too much, sir. Okay.
Here's the receipts, I got 10 out of 13 returns and 3 notaries.
Great.
And it's for a variance to build a 24 by 24 garage next to my existing garage, and I'm taking down the existing garage and using the pad as a carport attached to the garage, the new garage.
Okay, and as you are aware, we were out to take a look at the property.
Yes.
And, you know, I found no issues as far as I go. I'm going to open it up to any board member for commentary or questions. Okay, there being none, do I have a motion to approve?
I'll make that motion.
Do I have a second?
I'll second that.
All in favor?
Aye.
Aye.
All
You're
right,
all
thank
set.
you, guys.
You can follow up with the building department.
What's that?
You can follow up with the building department.
Yes.
Have a good night. Is there any other business before the board? We have a copy of the March minutes. Do I have a motion to approve the March minutes?
I'll make that motion.
Do I have a second?
I'll second.
All in favor?
Aye.
Aye. Okay, I think that concludes our business. Good night, everyone, and we'll see you again in May. Sorry.
Make motion to adjourn?
Do I have a second?
I'll second.
All in favor? Good night.